So before we start, as ever, there are a few items to note, if I may. This is, of course, a pre-recorded session, but if anyone does have any questions, comments, feedback, I would encourage you to reach out to me using the contact details in the course materials. The content today, which will be condensed into about 45 minutes, is necessarily somewhat selective, indeed highly selective. It will not surprise anyone to hear a significant amount of material to cover, and the course materials themselves touch on more than probably I'll be able to cover in the time available. But I hope today will give a flavour of the direction of travel as we move forward. The aims of the session today, first and foremost, it's intended to provide a snapshot overview of the context that we find ourselves in, within which IP law and, of course, related disputes in this jurisdiction are developing, and which is, of course, significantly impacted by Brexit, although the precise nature of that impact remains somewhat unclear. I should also say at the outset that the focus of the session today is really on soft IP, so the law around patents and related disputes is beyond the scope, although, of course, some of the principles I'll be talking about around jurisdiction more generally will be equally relevant. Relatedly, we'll cover some of the recent jurisdictional developments, legislative and judicial trends, and issues that have arisen over recent months and years, and which continue to impact IP disputes, IP litigation, and will do so, many people expect, over the months and years ahead. And within that discussion, we'll talk about a number of interesting recent cases which provide nice examples of some of the issues we'll be talking about and how those play out in practice. And again, as will be clear, there is presently some considerable uncertainty as to precisely how things will shake out. So the Brexit dust is far from settled.